All right, welcome back, everyone. We are now back on discussing the buyer agency agreement for Greater Capital Area Association of Realtors in DC and in Montgomery County, Maryland. So we are going to jump right back into where we left off a few minutes ago and proceed on with our lesson here. So where we left off, we were discussing the broker compensation and how that works. So again, in paragraph A, the buyer agrees that the broker will receive a broker's fee of blank percent or a specific dollar amount, whichever applies. And the agent will fill that in and work that out. And that is usually paid on the if we're negotiating a listing that is located within the Bright MLS, then that commission payment will also be paid by the seller as long in the amount of what is indicated here on this particular listing. This particular one shows a 2.5%. And that's what it would be paid at if you were in a buyer agency agreement. Notice that as a subagent, there is zero compensation. So subagency is never a scenario, in my opinion, is never a scenario that is advisable for a seller or a buyer to be in. We can talk about that at another time. We've discussed some of that in prior classes, but subagency is not an advisable scenario for most consumers to be in, but it is an option out there. And in this case, this listing brokerage is not offering to pay a commission on this particular listing for subagency, but they are willing to pay 2.5% on this one. So that's just what this particular one is doing. And that's where we are. So let's jump back to the document and we will continue talking about this. So even though we are looking to the buyer to be responsible for paying the commission, and in the event that it is an MLS listed property, the seller will pay that on their behalf per that stated amount. And if there's any difference, then we would look to the buyer to cover the difference of that. And the whole reason for that is because we have an agreement with you as the buyer to represent your interests. We don't have an agreement with the seller for the compensation. Therefore, we need to look to you for you to compensate it. But in the end, as long as it's a listed property, we don't have to worry about the compensation, assuming that that amount meets or satisfies this amount. Okay, the broker is authorized to receive all commissions offered, and such payment shall be made with the seller's and buyer's prior knowledge. So by disclosing this in advance, showing you where that is coming from in the MLS, that's how we are amounting to that information. So that is your prior knowledge. We're having this discussion today. I'm showing you that, and that's why you are being made aware. And so this is the satisfaction of that provision. In the event that the seller does not pay the total commission amount, the buyer hereby agrees to pay the difference. So we just said that a minute ago, due to the buyer's broker up to the full amount. The buyer also agrees to pay additional commission in the amount of blank, if that is so needed. And there can be an opportunity here for a retainer to be charged as well. And a retainer would be deducted from the total compensation owed. So if this is a certain number here, then we would subtract this from this number, this retainer amount, and then the balance of that would be owed at settlement. All right, the protection period. Commission shall be paid to the broker if a property is purchased by the buyer within blank days after the termination of the agreement. So this is a provision that protects the interests of the agent, and it's a fair provision. So let's assume that the term of the agreement is for 30 days. okay, or 6 months, let's say, or 6 months, either way. So at the end of the 6 month period of time, let's say on the very last day, I show you a property and you like it, but you didn't, you think you need to think about it some more in order to buy it. And the following day, our agency agreement expires. Down here, we're going to talk about that in a minute. It expires tomorrow, let's say, and then so tomorrow comes and you call me up, or maybe even a week later, you call me up and say, hey, you know what, that property we saw, I'd like to go ahead and write an offer on it. We can proceed with our agreement here, our buyer agency agreement, without having to reconstruct a new buyer agency agreement, because if we are within a certain amount of days within here. So we would fill in this blank. Maybe it's 30 days, maybe it's 60 days, so that it would extend only for the properties that you had seen with me, that I had shown you previously. And now we are working towards getting you a ratified contract there. And that's really, in the interest of fairness, because we did introduce you to the property. We did, and we are continuing to work together. It's just to have a continuity of things moving forward. Now, that is unless the buyer enters into a new buyer agency agreement with another agency, period, with another company or with another agent. So we have one buyer agency agreement at a time. If on the expiration of our agency agreement, you sign a new one with another company or another agent, that's fine. Then this paragraph would be eliminated in that case, because the new buyer agency agreement comes into play. All right, the amount of commission offered. Commission paid by the seller is generally indicated as follows: in Bright MLS for any properties using the multiple listing service, or in an addendum to the purchase contract for a new home construction or properties unlisted in Bright MLS. So most of the transactions we're going to be doing are probably going to be sourced from Bright MLS. Most of them will have that compensation amount that we talked about before, and indicated in the buyer agency field. So most of the time, the majority or the entirety of what our compensation is for buyer agency agreement will be covered by what's in the MLS paid by the seller. Okay, paragraph D. Payment of commission. Commission is due at settlement unless the buyer, after the sales contract acceptance, fails to perform or is otherwise in default of the sales contract, or executes a release to which the broker is not a party of the sales contract after all contingencies thereunder have been removed. In such case, the commission is due no later than the previously agreed settlement date. If the buyer enters into a contract with the seller during the original term of the agreement, and the seller subsequently defaults, then the original term of this agreement is extended by the number of days property was under contract. So that's pretty self-explanatory, but if you have questions about it, feel free to give me a call or send me an email and we can further clarify it. The term. This agreement commences when signed and expires at 11:59 p.m. on blank date. So we would actually insert an actual date in there to determine when this agreement expires. And for effective purposes, in using GCAAR forms, we use 11:59 in GCAAR forms as our cutoff date for the expiration of contingencies. All right, unless extended in writing. So if we wanted to extend this agreement in writing, we could add an addendum to this and then extend it by, another X amount of days, or unless I earlier terminated as provided herein. And we're going to talk about termination here in a minute. If a contract is entered into by the buyer before the expiration date, which provides the settlement to occur after such date, this agreement shall be automatically extended until the settlement date has occurred, or until the contract of sale is released in writing by the parties. So basically, Even if our buyer agency agreement expires in the middle of our in the middle of our sales contract and our contract before settlement, this buyer agency agreement extends through the settlement. All right, termination. So in Washington, D.C., D.C. law requires that this agreement may be terminated prior to the expiration date only by mutual consent. So if I decide that I can no longer be working with you, I can't unilaterally just terminate this buyer agency agreement with you. I have to have you agree with that, and my brokerage has to agree with that. The agreement, this buyer agency agreement, is between my brokerage and the consumer, the buyer. It is not an agreement between the buyer and me as an individual agent. It is my brokerage that has the authority to terminate, and not me in Washington, D.C. And that needs to be mutually done in writing and signed in writing. So that's the way that it needs to happen in D.C. In Montgomery County, Maryland, the law is a little bit different. And so the brokerage relationship established by this agreement may be terminated unilaterally. So if you, as the buyer in Maryland, Montgomery County, Maryland is only what we're talking about, because this document only covers Montgomery County, Maryland, and DC. But in Maryland in particular, if you decide that you no longer want to work with me and Remax Realty Group, then you can send a written notice and signed notice to the broker and to myself, and that will terminate the relationship, and by either party. So I can do that, or you can do that in Maryland. It's a unilateral, it's a unilateral cancellation of the agreement. So one person can do it. DC requires both parties to do it. Maryland only requires one party to do it. So and that would become effective in blank number of days. So Maryland law does define and does say that we can make it effective within a certain number of days, and we would put that number in there. And usually that number of days is there to be a cooling off period, just to make sure that this is truly really what we really want to do, and is end the relationship or not. And offer the opportunity for reconciliation if there's a problem, or if it's just not working out, then it can just take effect on that day. Even if the brokerage relationship is terminated under the terms above, the contractual obligation shall remain in full force and effect unless terminated by mutual written consent of all the parties. So if I have a buyer agency relationship with a Maryland buyer, and that relationship is unilaterally terminated, my obligations to that buyer do not end just because the buyer agency agreement has ended. So if that buyer has disclosed private communications to me about their willingness to pay, I'm going to use an example here, their willingness to pay $1 million for that $500,000 property, I cannot reveal that to any other parties. I have to keep that kind of information private and confidential. So that's what that is basically saying. And similarly, there are many other examples of that, but that's just one example of what I can and can't do. I have to keep that private privileged information that I gained while we did have an active buyer agency agreement. I have to keep that confidential. All right. So in addition, the terms of paragraph 4B, protection period, shall survive even if this agreement is terminated earlier. So that's pretty much that. Paragraph 7, disclaimer and limitations. Buyer acknowledges that the broker is being retained solely as a real estate agent and has been advised to seek professional advice for legal, tax, appraisal, home inspection, surveying, engineering, and other matters. So I am only a real estate licensee. I am not a tax professional, and I am not an attorney. I am not an appraiser. I am not a home inspector or surveyor or engineer. So if you're looking for guidance on those specific things, you need to seek out the representation of those professionals who are more suited and more knowledgeable about those things than I may be. I may have some knowledge about those fields, but you need to rely on those professionals, as a consumer, to get that kind of information. So tax information, what the taxes, what the breakdown of the taxes of the income tax deductions are, or the legal implications of a paragraph, or the home inspection, that crack in the wall, is that a home inspection issue? I'm not a home inspector, so I can't say that's a safe crack or that's not a safe crack. You need to rely on the home inspectors and the engineers to guide you on that. So we'll point you out in the right directions and provide you with some services, but we're not those specialists. All right. The buyer acknowledges that the broker may represent other buyers and that other potential buyers may consider, make offers on, or purchase properties through the broker. And it may very well be the same property that you're looking at. It doesn't usually happen. It rarely happens that way, but occasionally it can. So just be aware of that. And if we get into a situation like that, then I will bring that fact up at that time, that, hey, I've got another buyer who's also looking at this property. We need to discuss how we're going to handle this, and whether or not we need to bring in somebody else to manage the situation. So the buyer consents to broker's representation of other buyers before, during, and after the expiration of this agreement. So I may have other buyers, I may have other sellers that I'm working with. I'm not, I don't have any limitation as to what, manage of my flow of clients that I work with on a daily basis. Upon receipt by the broker of a ratified contract to purchase property pursuant to this buyer agency agreement, the broker shall have no further obligation hereunder to procure any subsequent properties for the buyer. So once we get under contract, we're focusing on that contract. We're focusing on that property. We're not looking for other properties, because we need to focus all of our legal attention to that property and making that transaction work. If we're looking elsewhere, we could find ourselves, and looking elsewhere for other properties, we could find ourselves distracted in a legal sense, and find ourselves in a way that would put us in jeopardy if we pursued that too far. So we're only going to be focusing on that one property. Buyer agrees that the broker may perform ministerial acts for the seller. A ministerial act is a routine act that does not involve discretion or the exercise of the broker's own judgment. Buyer acknowledges the possibility that the seller or seller's representatives may not treat the existence, terms, or conditions of the buyer's offer as confidential information. This last sentence is very important. You need to understand that your offer, once we submit it to the opposite side, may not be deemed confidential by the opposite side. And that's pretty important, and because if we're in a competitive offer situation, there's a good chance that your offer may be used as the basis to escalate another offer. So you need to be aware of that as we're moving into transactions. And there's no way for us to prevent that. That is just the nature of the way that our business is structured, and the way that the law kind of allows the listing agent and the seller to disclose that kind of information. Same situation is reversed if we're working with a seller. The opposite applies. All right, the general provisions, the laws and regulations. Let's see, how are we doing on time? Oh, we're doing good. Buyer acknowledges that the broker must comply with federal, state, and local laws and regulations. The buyer understands that as a realtor, meaning a member of the National Association of Realtors, the broker must also adhere to the code of ethics promulgated by the National Association of Realtors. So we have a code of ethics that we as realtors have to live by and operate under. Not all real estate licensees are realtors, but most of the large brokerages and chains are all part of the National Association of Realtors. Remax Realty Group is no exception. So we have to conduct ourselves within the code of ethics. All right, delivery or delivered means hand carried, sent by overnight delivery service, sent by wired or electronic medium, that can be fax or that can be email, which produces a tangible record of the transmission, such as a fax, email, which includes an attachment with an actual copy of the executed instruments being transmitted, or U.S. postal mailing. In the event the overnight delivery service, delivery will be deemed to have been made on the next business day following the sending, unless earlier receipt is acknowledged in writing. In the event of U.S. postal mail, delivery will be deemed to have been made on the third business day following the mailing, unless earlier receipt is acknowledged in writing. All right, notice this agreement shall be deemed enforceable when it and all addenda and any modifications thereto have been signed, initialed where required by the buyer and broker or supervising manager. So we talked previously how there is the broker in charge of the company, or the in charge of the company and the jurisdiction. Then oftentimes there are supervising managers of other companies, of other offices within that company. I happen to be one of those in DC, and so I am designated by my principal broker to have that authority and delivered to the other party. So if there's any kind of legal notice that has to be delivered by us, then buyer and the broker would initial that and send those to the opposite party. Those are notices in between the two entities, the brokerage and the buyer. All right, paragraph headings. Paragraph headings in this agreement are for reference and convenience only and do not define or limit the intent, rights, or obligations of the parties. So what they're talking about is just these paragraph headings that are bolded and underlined in some places. That's just what they're talking about there. Some basic definitions. The singular shall be the plural shall be the singular. The use of either gender shall include the other gender. That probably needs to be revised. I sit on the forms committee, and that should probably be revised. Term seller shall include optioner and exchanger. The term buyer shall include optionee and exchange. All right. So the inclusions agreement and receipt. This document and the documents below contain the full and entire agreement between the buyer and the broker and supersede any prior or contemporaneous agreements. If any, whether written or oral, between the parties, each acknowledges receipt of a copy of this agreement in accordance with the Maryland and/or District of Columbia law. Included with this agreement are, and in this case, we are talking about in Maryland, the consent for dual agency. We'll talk about that in a minute. And then in DC, the consent for dual and designated representation. We'll talk about that in a minute also. Dual agency. In the event of dual agency, when either the buyer or the broker declines to consent in writing to dual agency, either party may terminate this agreement by written notice to the other party. So if dual agency is not desired, whether it's in Maryland or DC, if the consumer decides they don't want to be in dual agency, then the brokerage can decide to terminate the agreement, or vice versa. Can also be the vice versa. We would add additional provisions here, and the parties would sign and date, the brokerage name, the broker name and signature would appear up above, the firm and the broker address and the phone number. All are parts of that. All right, so that is the discussion of the buyer agency agreement itself. And then consent for dual agency, we talked a little bit about that, the consent of that. So here is where we would bring in that consent for dual agency that was mentioned. Where do we go here? There we go. So in Maryland, the consent for dual agency. And that's where we come back up to here, and that's this form. So you are agreeing in advance to being in dual agency. And then when it comes time to actually being in dual agency, you have to reaffirm it. So the signature comes in, we disclose it up here first, and then once it comes to the point of actually being in dual agency, where you've identified a property, identified that in Maryland that the brokerage is representing the buyer and the seller, that you would affirm to agree to continue on in the process there, or you decline it, and then we potentially would terminate the buyer agency agreement at that point. So that is where that falls into place. There's also a similar document for DC. So when we talked, going back to the buyer's agent agreement in this, the consent for dual and designated representation, we move down, and that is this form. And this is where we are going ahead, and we've identified a property, 123 Main Street. Remax Realty Group is acting as a dual representative for the sellers and the buyers. So the brokerage is in dual agency, is in dual representation. And then we further define it by saying that the sellers or landlord and the buyer or tenants are proceeding with the transaction, acknowledging below. And now this is DC only, designated representation would be if I am representing for example, the buyer, excuse me, the landlord in this sentence, I would be representing the landlord or the seller. And then the brokerage, my company would have assigned, let's say, Sally Smith to be the representative of the buyer. So that's what that would be. Sally Smith would represent the buyer, I would represent the seller, and the company is in dual agency in that situation, but the individual agents are designated representatives. If I have a listing that I'm representing, and if I have a buyer and I'm representing in DC only, that is a legal arrangement that I may go ahead and do legally, and that is called dual representation. In one property, one brokerage, one agent represents two parties. Okay, it's a lower standard of service that is provided to the two parties, and it's a lower standard of service because we can't provide complete fiduciary loyalties to both parties, because privileged information of one cannot be revealed to the other. There is factual and material things that must be disclosed, and contractual terms that must be disclosed, but the privileged communications and the privileged information and the counseling and advice, I can't advise the buyer on ways to be advantaged over the seller. I can't advise the seller to be advantaged over the buyer in that kind of a situation. Normally, in a buyer agency situation where I'm designated or where it's another company altogether, I would be able to do that. But because I'm the single person involved in dual agency, the single agent involved in dual agency, I cannot give that kind of preferential treatment. So I have to become more impartial, and I have to reduce the amount of loyalties. I have to eliminate the loyalty aspects, and I have to be more of a task taker. And so and that's where it gets a little tricky. In my opinion, I choose not to do dual agency as a matter of business practice in DC and in Virginia, because I do believe it's a conflict of interest. But it is completely legal in DC and in Virginia. In Maryland, what is known as dual agency is actually what is dual agency in Maryland is designated agency in DC and in Virginia. So I don't have a problem being in Maryland defined dual agency in Maryland, but I do have a problem being in DC defined dual agency in DC and in Virginia as well. So, and I don't do that as a matter of my own business practice because I prefer to have one client that feels very good about the way that I served them and the loyalties that I gave them than to have two clients who maybe feel I was less than optimally servicing them. That's just my philosophy, but everybody has their own take on that. So that's the discussion. And if anybody has any questions, feel free to give me a call, 202-309-2339 or adb@goodvibehomes.com. And thank you very much for joining us. And this discussion was not a legal advice. It is solely a discussion of my experience over 26 years in the industry. Thanks so much. Have a great day. Take care.